Do you want immunity from prosecution under the Customs Act? Then Settlement Commission is the answer. Stay tuned for more information.
For latest updates, subscribe to our channel and press the bell icon.
Hello everyone, I am Viren Dayal, a faculty and trainer and a custom broker, and today I am going to tell you more about Settlement Commission as one of the dispute resolution schemes of the Indian Customs. So in the administration of fiscal laws, the primary duty of the government is to collect revenue, and therefore there should be a room for settlement. So when we have settlement of cases under the Customs Act, it saves a lot of resources of the investigating agencies. At the same time, errant tax defaulters get a chance to come clean, and therefore the Settlement Commission was enacted in 1999. The Custom Act currently provides that any assessee, that is an importer or an exporter, can approach the Settlement Commission before adjudication of a case. That means an importer or an exporter has filed a bill of entry or a shipping bill and has received a show cause notice, but after receiving the show cause notice, the adjudication procedure, that is a final order from the adjudication authority, is pending. During this time, the assessee can approach the Settlement Commission. The law provides that when a show cause notice is issued for any disputed duty of at least rupees 3 lakhs and above, the importer or exporter can approach the Settlement Commission to settle the case as long as the assessee makes a clean disclosure of all the duties not paid earlier, and at the time of application to the Settlement Commission under Section 127B of the Customs Act 1962 makes the full payment of the entire duty liability along with the interest as mandated under Section 28AA. And thereafter, the application is processed by the Settlement Commission. However, an importer cannot approach the Settlement Commission for disputes regarding classification of goods or any case pertaining to the Narcotics and Psychotropic Substances Act, or any case pertaining to burden of proof in certain cases under Section 123, or SCOMAT items. In these cases, the Settlement Commission cannot be approached. Once you approach the Settlement Commission, please remember that you cannot withdraw the application. It's like once the Brahmastra leaves the bow, it must hit the target and cannot come back. In a similar way, the application to Settlement Commission is final and cannot be withdrawn under any circumstances. Similarly, an assessee, that is an importer or an exporter, cannot approach the Settlement Commission at the same time parallelly approach the appellate authorities or the High Court or the Supreme Court. Therefore, the option of approaching the Settlement Commission by an assessee is primarily to seek immunity from prosecution, provided the prosecution proceedings have not been initiated against the importer or the exporter. Only then he can approach the Settlement Commission. Also, what is the reason that importers, exporters approach the Settlement Commission is because they don't want to face the harsh criminal proceedings which are under the Customs Act 1962. Therefore, the Settlement Commission provides an opportunity to any errant taxpayer to come clean by making a full, true and a complete disclosure of all the duties and liabilities under the Customs Act, and thereafter he can be granted immunity from prosecution under Chapter 16 of the Customs Act. At the same time, he can also be pardoned or reduced penalty can be taken from the assessee. the award of the settlement commission will be not less than the total duty liability which has been disclosed by the importer or the exporter. As an example, if an importer-exporter discloses a complete liability of rupees 15 lakhs, that is more than 3 lakhs, then the award of the settlement commission will be at least rupees 15 lakhs. But importantly, it grants immunity from prosecution. At the same time, it lowers the penalty levied to the importer or the exporter. The settlement commission award has to be paid in a time-bound manner, and it has to be, if it is not paid, in that case, the assessee or the importer, whatever immunity has been granted to him under the Customs Act is withdrawn, and then he is tried with all the remaining procedures and criminal offences as the case may be. Also, in case the settlement commission finds out that importer or the exporter has obtained some information by fraud or maybe collusion or misstatement of facts, in such cases also the immunity granted to the settlement commission will be withdrawn. The settlement commission is a quasi-judicial authority and its decision is final and cannot be challenged under any other statute in India as an appeal. I hope you liked this small note on settlement commission, and stay tuned for more updates. Thank you.
Chapter details of Chapter 14A. Settlement of cases. 127A.
Definitions.
127B.
Application for settlement of cases.
127C.
Procedure on receipt of an application under Section 127B.
127D.
Power of Settlement Commission to order provisional attachment to protect revenue.
127E.
Omitted.
127F.
Power and procedure of Settlement Commission.
127G.
Inspection, etc. of reports.
127H.
Power of Settlement Commission to grant immunity from prosecution and penalty.
127I.
Power of Settlement Commission to send a case back to the proper officer.
127J.
Order of settlement to be conclusive.
127K.
Recovery of sums due under order of settlement.
127L.
Bar on subsequent application for settlement in certain cases.
127M.
Proceedings before Settlement Commission to be judicial proceedings.
127MA.
Omitted.
127N.
Application of certain provisions of Central Excise Act. For detailed learning of all logistics subjects, visit www.logiveda.com.